So thinking about what needs to be assessed, for all capacity assessments, we are looking at the person's ability to understand the information relevant to the decision. Can they keep it in mind long enough to discuss it and weigh it up? Discuss it terms loosely. They don't necessarily have to be able to just speak as normal in discussion. To be able to weigh up that information as part of the process of making the decision, to consider their options, and to communicate her or his decision, whether that be talking, using sign language, or any other means that is consistent and that we can be sure of. So what we assess for signing and certificate providing for lasting power of attorney comes into 4 sections. So what is it, which is basically part 1 of this talk? When would it apply? So what does it mean to lose capacity? Again, see the previous slides. And what the person would choose in terms of when it would apply, because this can be different depending on the type and the choice for property and financial affairs, which, as we said earlier, can come into play straight away, or can be used only when the donor has lost capacity to make those decisions. The next section would, who would you want to be your attorneys, and do they want this responsibility, and what are the risks? So we always cover this even if it's hypothetical. So the donor might say to me, I completely trust my attorneys that I've chosen. They would never do anything that's not in my best interest. I would still go through, okay, but hypothetically for other people, what are the potential risks? So potential risks could be things like, this person is now going to have access to your bank accounts, and if you've chosen for it to come into play straight away, that means they could go to the bank as soon as it's registered and they've got it back, and be accessing your money and your funds. And obviously we would hope that the attorneys only do that for the donor and in their best interests. But some people unfortunately do abuse this possibility to access money for themselves. So looking now at how this is assessed, again, thinking back to Principle 2 of the Mental Capacity Act, which is not to treat people as incapable of making a decision unless all practicable steps have been tried to help them. So here we use what's called a total communication approach, which is delivering information using spoken words, written words, and pictures. And I really like this method because it helps with language difficulties. It helps people understand what it is that we're talking about and showing them. But also for my patients with memory difficulties, having the pictures laid out in front of them reduces the memory load. So when we're doing a capacity assessment, the memory stipulation that somebody's got to be able to hold the information in mind whilst weighing it up, that's not supposed to be a memory test. If you can support memory to make this process easier, you should do so. And the pictures that we can lay out to support language with those words as well can support memory as well as language. So I really like that. Also, part of my job is to consider how we're delivering the information. So that can be to do with how much information someone can process in one go. Do we need to break the sentences down into more manageable chunks? I can also be looking at how much someone can do fatigue-wise in one session versus how good their carryover is to the next day. So if someone can cover a lot of information in one session and can eventually do the whole assessment in one session, but they forget the information later, once they've made the decision and demonstrated that they've weighed up the information, understood it all, and remembered during the assessment, you don't need to come back the next day and be like, right, tell me it all again from memory. That's a memory assessment, not a capacity assessment. But for other people, they may be able to learn over time, but not cover all 4 sections of what we assess in one go. So part of my job can be looking at how we support memory best to achieve a capacitous decision. So here's some example stimuli that we use. For a proper card sort method, you should have some correct information and some not correct information so that people can demonstrate that they have understood what power of attorney is, not just by their yes responses, but also by their no responses. So, for example, if somebody was looking at power of attorney for property and financial affairs, that does not allow you to change someone's will, or make decisions after they've died, or make their health and care decisions. So there'd only be one of those that should be card sorted onto the yes pile. So again, some of these are relevant on these stimuli for the health and welfare decision, and some of them are relevant to finances. And so we would assess one power of attorney at a time and present these to be card sorted so that people could demonstrate that they understood what power of attorney each one doesn't do, as well as what it does do. And also sometimes we would need to do a more general assessment of somebody's understanding of their abilities. So it can be the case that somebody has pre-existing knowledge of what power of attorney is and is pretty good at sharing what that is, but they may not have insight into their own difficulties. So they might think of power of attorney, if they're going to sign it, as something hypothetical to be, in the long distant future, but actually they need this help now. So we might also look at somebody's understanding of their abilities in general, of what they think they need help with and what they do not think they need help with. And with that, we might need to personalise. These ones are examples the speech therapist made for a general assessment. And they can, not everything has to be perfectly done off the internet if we need to. They like to upgrade to some decent pictures, but in the moment, if you need to add stuff in, they'll draw little pictures and add words to it on post-its to make this possible. So thinking about who will do this, occasionally the NHS might help you with certificate providing. It depends on the service. So currently we do at SRC, but I know plenty of rehab services that would consider this a legal document and not their commissioned remit, even if they're capable of doing it. So some NHS services will, some don't. It also depends where on the pathway. So my colleagues in acute stroke don't get asked to do this because it's too early on for people to be either thinking of this or demonstrating they've got capacity. So it's usually when someone has a chance to be somewhere for a more extended period of time and to start thinking about these things, and their relatives start thinking about these things, that this question gets asked. Also, from SRC, some people are getting ready to go home and there may be changes that need to be made. There may be financial things that need sorting out to make that happen. And so that's one of the reasons that we currently offer to certificate provide here, is that can make discharge a lot easier if you have capacity and can choose to appoint an attorney who you trust to help you manage things before and after you leave hospital. That can very much smooth the discharge process for somebody. A solicitor can help with this, and I would urge people to consider using a Headway approved solicitor who would hopefully have some understanding of brain injury, or potentially thinking about commissioning a private assessment. So that might be on an earlier slide, we had the list of people that could be certificate providers, and they may offer services privately to do this assessment. There is the possibility of a lay certificate provider, as we talked about earlier on. The only issue with this can be if there's any challenge to that later, and somebody, say within the family or a friend, says, I'm worried that the person signed this and actually the certificate provider was wrong. This person was in hospital, they had all these difficulties, they had communication difficulties, they had memory problems. How do you really know that they actually understood what they were signing? So it's usually easier to challenge a lay certificate provider. If I do an assessment, it always comes accompanied by a report that goes through exactly what I assessed, how I assessed it, and why I came to the decisions that I made. And so if that needs to be presented by the attorney to, or by the donor, to the Office of the Public Guardian or the Court Protection, they have it ready to go, basically. I mean, that could still be overturned by a court if they want to, but at least I've provided with that report my evidence and why I've come to the conclusion that I have. So that is a whirlwind tour of power of attorney. I'd like to thank Stella, who provided feedback on these slides, and I believe we have a discussion point in a bit about exactly when somebody can use the power of attorney. To Headway for inviting me and hosting, and to yourselves, of course, for coming. Okay, any questions? So I wonder if I can unmute Stella, and before we... Great. Stella, you had a thought that something that I wasn't sure about. Can you talk further on that, about when somebody can choose to use their power of attorney? So when the donor can be asking for that to happen.
Yeah, so obviously it's different with health and welfare, because an attorney would be making that decision if somebody lacked capacity. But it was really, no, I think it, I don't know, I was probably a bit tired when I was reading your slides. I think it was because we actually have some cases where we act for people when there's absolutely no issue about their capacity. They just are fed up and they want somebody else to deal with it. So that was just, I think, the only comment I had. You know, that was it really.
Okay, so I think we covered that a bit, that you can choose for it to be that way in the power of attorney for finances. If you had the health and welfare power of attorney, or even if you didn't, if you have capacity to make a choice and you can understand, but you want your next of kin to, or anybody else that you trust to comment, that might not necessarily, I was thinking more on this is a more complex one. If a person wasn't giving us a decision because they couldn't weigh up the information, and I've had it before where somebody has fully understood each point, but there's a lot of complex things to be considered. Perhaps it's to do with going home with care calls, 4 care calls a day versus going into a residential home following hospital. And it could be that a person can understand each point, each pro and con, and then when I ask them to look across the whole of the information to weigh it up, they can't, they find it too much information to consider simultaneously, even though they've understood it all, and they say, I can't make a decision, I don't know. That's when either we would have to have a best interest meeting, or if there was a health and welfare attorney, they would make the decision. If they felt able to, they might still ask for a best interest meeting. But if you were uncertain and you wanted to ask friends and family what they think you should do, as long as they have as long as their response also has weighed up all the information, then you wouldn't necessarily have to have power of attorney to say, well, my partner recommends this and I think that's a sensible suggestion, I'm just going to do what they think because they've helped me make the decision. It would get complicated if the partner was saying you should do this because of, and then their reasons weren't understanding the information themselves, and then you, by virtue of just copying what they had done, would not be showing capacity if they hadn't understood the information. So it can be a little bit complex of when it kicks in, but we can work through it here at the hospital. Okay, I think that's it, Sam. We can stop recording and go to questions if anyone's